we're really trying to not just look at what's happening now, but also look at what could be happening in the future so that we fully understand who are competitors now, but who might be competitors in the future and how that will work.
One of the fascinating but also challenging elements of digital markets is that they are cross-territorial. They don't have physical boundaries. So all competition authorities across the world have to look at these issues and think about them and what that means.
In particular with digital mergers, which are focused online and often involve large platforms, there's a lot of looking forwards, thinking about what might come in the future, and we have to really think about a kind of dynamic assessment. And in particular, we have to think, if we've got companies who are already in the market, who are big players, what might the future implications of a merger with a smaller player be, and what impact might that have in terms of the quality of service, not necessarily the price, because often digital markets have non-price effects. So we talk about quality, we talk about the range of services, we also talk about just the level of service that you as an individual will receive. And so we're thinking about those particularly in a future-looking way.
We're looking to develop our own intelligence. We want to upskill. We want to understand these markets. We want to build capacity. We want to put ourselves on a level footing with these big companies. So there is no difference between what we know and what they know from a technical level and from a competition level. So we can have meaningful discussions and look to sort of drive competition within these markets.
So I think one of the big challenges is keeping up with the tech firms and all of the kind of the algorithms and things that they're using. And that's one of the big reasons that we've now invested quite a lot in this new data team, which is the team that I'm in, where we've got about 30 data scientists, data engineers, and technology insight officers as well, to actually try and keep up with the technology firms. So we do employ AI algorithms, that sort of thing, to actually help internally in the CMA. So we build our knowledge, and we can also understand what's going on externally as well.
We need to think about how we can work flexibly and adapt, because one of the challenges of digital markets is that they develop at a really quick pace, which is fantastic because it means there's innovation which can lead to benefits for competition and consumers, but it also creates a challenge for competition authorities and regulators. And what we need to do to be able to, I suppose, identify issues before they really become entrenched, and what that means for how we work and what we do.
Good afternoon and welcome back to our live stream digital event. On the panel this afternoon we have some of the top enforcers and top academics in our field, and we are going to discuss some of the issues that came up this morning and some of the general themes that we are discussing quite often at these events. I have a great panel around me. Professor Diane Coyle is a professor of public policy at the University of Cambridge. She was one of the members of the Furman panel who produced the Furman report. Andreas Mundt, president of the German Cartel Office and chair of the steering group of the International Competition Network, which is the main international body for coordination among antitrust agencies. Professor Fiona Morton to my left, professor at Yale, former chief economist at the Department of Justice and lead author of the report for the Stigler Center on Digital Platform. There has been another very impactful report over the last year or so. Isabelle da Silva, president of the French Competition Authority and formerly judge at the Supreme Administrative Court in France. And last but not least, Rebecca Slaughter, commissioner at the FTC in the States. So I would like to take advantage of the panel and the expertise around me to try to make some progress on practical solutions, changes, institutional changes, what we want to see to actually see impacts in the near term. So how can we move from some of these excellent reports that we discussed, the Furman report, the Stigler Center report, into actual changes in the way we do things. So the first theme I want to discuss is Well, to fast forward a few years, and let's say we are now in sort of 2025, where do we think we will be in terms of competition and regulation, institutional features? Where do we think realistically we can get to actually address some of the concerns that are coming to us as agency heads? So I'd like to start with you, Andreas, on this particular theme.
Well, Andrea, first of all, thank you very much for having me here at this quite unusual setting. Maybe this is a bit the future that we see here with regard to sustainability also, and I like it a lot, and it's a new experience. Well, I think if you think about where we are heading to, maybe it makes a little bit sense to reflect a little bit where we come from. And I think I'm quite happy to say that today we have at least understood to a certain extent what is happening on digital markets. We know about network effects that are self-reinforcing. We know and we have accepted that most of these business models are purely data-driven. We have understood that there is a link between network effects and data, that this is kind of a feedback effect that both of these effects have in common. Plus, we see our task on the other side, that is to keep markets open and contestable and to protect consumers from abuse. This is what we know. If you look at the present, that was about the past. If you look at the present, we know we have had some success. If I talk for my agency, we have seen some successful cases in the digital arena. If you think of MFN clauses that we have done jointly by that time with the OFT, if you think of Amazon price parity clauses, if you think of successful cases that we have had in Germany against CTS Eventim because of exclusivity clauses on that ticket seller platform. But what we also see, for example, from court proceedings, and here again I think of cases that we have been dealing with, the Facebook case, the booking case with regard to narrow MFN clauses, we also know, well, that we have to have the peculiarities of these markets in mind, and that we are definitely not yet there where we need to get. The courts, to a certain extent, have shown some limits, maybe that we have to deal with. And what we have seen is that there is this natural tension between what we want to do on the one side, that is being fast and being efficient, being effective, and on the other side, that we have to go for thorough legal and economic assessment. So this is where we stand today, and we have to ask ourselves, how do we manage with this situation? And of course, what immediately comes, and there I'm in the future, do we need a certain kind of regulation in order to overcome the problems that are at hand? And I personally believe we do need some regulation, and I personally believe we will get some regulation.
Yes,
the question is, in which sense, in what kind of regulation? What I do not believe is that we need kind of a sector-specific regulation that we know from other areas of law. I do not believe in this. And maybe here Germany might be able, at least for our agency, to show a way, because we are currently in a debate about amending our law. And what we will do is that we introduce kind of a, well, we're still looking for the right expression. Maybe you can call it a regulation that is very close to cartel or competition law. Sometimes I call it cartel law plus or whatever. I mean, we're still searching. That is that we can declare companies to be of paramount significance for competition across markets. So that is something that is only valid for a few companies, that we can declare that these companies are of that nature, and that we can proceed by prohibiting certain kinds of behavior to these kind of companies. That is, for example, self-preferencing. That is, for example, envelopment strategies, establishing barriers to entry related to data, and other issues that we can deal with. There are other proposals in the amendment beyond that. That is that we can go better for companies and intervene below the threshold of dominance.
You think on that? What's the time frame you think
The
realistically?
time frame,
in terms
well,
of potentially having the
realistically,
law?
we will see a draft of the government in due time now, and I think this will be in place by the end of this year, at the latest by the beginning of next year. So I think this is something, and here I'm very happy that this is something that this is not a special German way. It is embedded in many deliberations that we see, at least across Europe. That we see in the UK as a consequence of the Furman report, that we see in the Netherlands, that we see also beyond Europe at the Australian colleagues and so on. So this is well embedded in an international process of deliberating how to continue with these companies and how to go there. So regulation, yes, but in a sense that this regulation should stick to cartel law as we know it and develop this cartel law. I think this might be a way further on. And if you ask me, this is where we will be in 5 years, definitely. And if we are not there, we will have much more and much stricter regulation. So I think companies who might be addressees of this, maybe they are well advised to cooperate in this sense in order to avoid much stricter regulation in the future.
So in a sense, going back to the 2025, you would say your portfolio will have some regulatory activity coming out of this, but still also some antitrust cases.
Yeah.
Some of the traditions. So it will be a combination of the two.
I think it will be a combination, and the regulatory character of the law will remind you a lot of what we have experience with and on what we are dealing with today. And maybe that is a good way forward.
Great. Thanks, Andreas. Isabelle, what's your sense on the French side? I mean, obviously, there's a lot of international discussion, and we're all kind of learning from one another, but also each of us, we're dealing with our own parliaments and internal discussions. So what's the picture in France?
Yes, so thank you, Andrea, for having me too. I have to say I missed the live audience, but I hope that those watching on the internet will find it quite valuable. I think that we are in a better place after all the work that has been done for the different reports. I think that those reports were really useful, and that there is a sort of coherence in those reports, even though the solutions might be quite different, but we see some common elements. Like Andrea said, I think that the picture in terms of economic analysis of what is a platform, what makes it different from other incumbents we've done in the past, I think now those are obvious truths for most enforcers. So that is helpful to have this big picture that is the same more or less all over the world. Still, I think that in the future, we have some big choices ahead of us. If you look at competition agencies, I'm pretty convinced that in many jurisdictions, we will see more antitrust cases, more abuse cases. I think that when you look in the past, you had lots of abuse cases, at least in France and Europe, concerning traditional incumbents or monopolies at the time where a market was being opened, for example, in the energy sector or the telecommunications sector. So the new power today is in the hands of those big platforms, so it would be quite normal that you should see more antitrust abuse cases, and if there is not, then this might be a problem. But then among the choices that are ahead of us, it's really, do we need new legislation? So this is a choice that is in the hand of the parliaments or the member states when you look at the EU. But of course, as enforcers, we try to give good ideas and to say if we feel that we need new tools. I think that we need to make the most of the current tools that we have, but we are really in a collective thinking process. And I think, like Andrea said, that it is really something that hasn't happened before. I think that there is so much dialogue and ideas that are being exchanged. And we recently issued a proposal, a policy paper, that really builds upon the proposal from the Foreman report, the proposal from the German draft law, and also the proposal done by the Benelux competition agencies. And so in the end, the question is whether will the French government decide to have a law about a new type of tools, or will the EU decide that being part of this global digital strategy, they need some new elements. So what are the things we might see, and are they good ideas? I think that there is an idea today among the public that there is a problem with big tech. This is putting things in a very simplified way. We have been hearing about techlash or tech anxiety. It is quite striking that those platforms that were seen a few years ago as being innovators and bringing new things to the economy and to the public are now sometimes seen in a rather negative light because they might be detrimental to the global effectiveness of the economy. So this is something that everyone needs to address, and we need to be very specific in terms of what are the problems. For example, when you look about data privacy breach, this is something that should be dealt with by data privacy regulators mainly. I mean, it can be an issue from a competition perspective, but this is a clear problem that needs to be addressed in a certain way. Do we need can we say, for example, that competition enforcement as it is today has been a failure and needs to be completely overhauled? I think that would be really extreme and incorrect, because what we see is actual cases. Well, Andreas mentioned a few, but very important cases. I'm thinking, for example, of the different Google cases that have been decided by the Commission. We will have to see what the courts have to say about, for example, the Google shopping case. We at the French agency recently issued a decision finding Google about the way Google was applying rules on the online advertising market. And a lot of those decisions are about the online advertising market. So this is not by chance. I think this is also because it's such a crucial market for today's economy. And one of the ways in which we could add to the global legal framework is to think about some new form of ex-ante regulation. So there are some proposals on the table about data portability, data access that would apply to all platforms. We are more in the line of adding some very specific tools that would be a little more ex-ante, but still based on a case-by-case study. So what we proposed, and we drew inspiration from the German and the Benelux proposal, was to enable the agencies to be able to look at specific behaviors for specific structural platforms. And we proposed some elements to define such platforms, what makes them different from another type of company. And the idea is to enable us to intervene when we see a specific behavior, for example, self-preferencing, but still looking at the facts and seeing if we need to issue an injunction that would be, of course, a different standard than the one we apply for abuse cases. So the idea is to have really a tool that can be used in very specific conditions, but when the conditions are met, then the standard would be more easy to find than what we have in abuse cases that tend to be quite long, to be frank, and usually we need some years to be able to close those cases. So I think that we need maybe some complementarity between the traditional antitrust enforcement tools that need to remain, because they remain very efficient and they have a deterrence effect, but maybe to try some new form of legal intervention. We don't know if it will be really the solution to all ills, but I think we need to try and find a way in this new form of not really a sectoral regulator, but maybe the idea that we have a closer interaction with some specific companies. So I think that's what we'll be discussing in the next few months with the Parliament, because they have some proposal on the table at the Parliament right now in France, and also with the European Commission, which is looking at answers, and we are really able to propose some things. And maybe a final word, for me, a merger is really a crucial issue. I think we need to look at merger within the current legal framework in a much more thorough manner, and being more demanding in terms of what type of mergers can be approved. And we also need to solve the fact that some mergers are not really on our radar, and I think that's a problem in France and in Europe. So we made some proposals to be able to look at those specific mergers, for example, by those very big, dominant or structural platforms that have, this has been mentioned this morning, a tendency to acquire lots and lots of companies, and I think we need to get a closer look at those.
Yeah. Thanks, Isabelle. I very much agree with your point on mergers. I was talking about it yesterday. Rebecca, on the US side, I mean, obviously from our point of view, I mean, your politics are a bit more open at the moment. You know, obviously you have important elections in November. So in a sense, if you're trying to project forward, whatever happens in November will have a bearing on it. But if you were to try to predict.
Sure. Thanks, Andrea, and thank you so much for having me here. It really is a pleasure to be here with such esteemed colleagues and be a part of this conversation. Before I came to the FTC, I spent about a decade working in the US Congress, and if I learned anything from that time, and in particular from the last 5 years, it is that predicting what is going to happen in the US political process is not my greatest strength. Maybe it's not a strength at all of mine, maybe not of anybody's at this point. So instead of predicting what will happen, I think I can focus on what I think should happen and where I think a lot of the attention is focused in the US. I think similar to what Isabelle and Andreas have said, there are a lot of questions in the US about, does the law need to change? Do we need regulation? Do we need different enforcement? And I don't see these things as mutually exclusive. I think we need to both be more robust in our enforcement efforts and consider the ways in which the law might need to change to facilitate enforcement or to limit the need for enforcement by limiting problematic conditions in the first place. And so I think we have been and need to continue to be engaged in really thoughtful analysis about how evolving market conditions put demands on us as enforcers and where we are seeing the biggest problems in concentration in the economy. I was glad when the FTC chairman stood up the Technology Enforcement Division in the last year to really focus particularly on the kinds of cases and the kinds of questions we're seeing arising in the digital platform space. I also think the FTC has been and should continue to leverage its market study capabilities in terms of 6B studies. So we recently announced a study of what have been in the US non-reportable acquisitions by large tech companies so that we can better understand both the patterns of acquisitions, whether there might be problems there, whether we might have a problem with how we structure reporting, which is right now just based on size of the transaction, and is that really the best mechanism to capture mergers that might be competitively problematic without over-capturing mergers that are not.
So Rebecca, just a very quick question for the audience on our side of the Atlantic. Is there going to be a study published out of it? I mean, because it's a process we're not very familiar with. I mean, obviously it's very interesting, and it's very interesting to lots of other people.
Sure. So I will note that I am not the chairman and I am not a majority commissioner at the FTC. So I'm like a 20% shareholder in a closely held corporation, which means I don't get to decide what happens as a result of these things, although I can certainly offer my opinion. So I don't know.
So it's not decided as yet.
No, and I think it would benefit us to the extent that we learn things that are important for our enforcement and globally helpful. I think it would benefit us and our colleagues internationally to share as many of those insights as we can. I benefit from reading the reports that the CMA, the Australians, and the Europeans have put out, and so I think that it's hard for me to see an argument against doing that, but like I said, I'm not in charge of that particular decision. We do not have the same kinds of market study, the same kinds of powers to do orders coming out of a market study that the CMA has. It's really information gathering, but it can help us tool our enforcement efforts and hone our enforcement efforts and think about where other rules, like our reporting rules, might need to change. I don't think these small acquisitions is the only area where we should be deploying this tool. I think my colleagues, Commissioners Chopra and Wilson, have talked about wanting to do a study into the ad tech market, which, again, many other jurisdictions have done, and I think we're a little bit behind on in the US. I think it's a very good idea, making sure that we fully understand the infrastructure of these economies that aren't necessarily the consumer-facing sides, but are where the money is going, is really important. So using more study power is good. Bringing more cases is good. And I think sometimes that involves taking on litigation risk that we have not always been excited to assume in the past. But doing that is important. Where we think the law has been violated, we should bring cases. And if the courts end up stacking against us, that can help us make the case for the law needing to change. And actually, so the point I was going to make about the law needing to change, I think we have seen some evidence in the US in the last few years as we've had a series of, I think, very problematic decisions in antitrust cases that suggest that the way we have been doing our litigation so far isn't really enabling us to protect competition and competitive markets the way we need to be. So I think that we could consider whether some of the laws that we're enforcing need to change in terms of maybe adding different presumptions or making sort of clearer, bright line structural rules, because, and I know Fiona is intimately familiar with this, we can get into cases where very, very good and smart experts give lots of lengthy, well-researched testimony, and judges kind of throw up their hands in confusion at the end of the day, and that's a real challenge for us. So what laws need to change in terms of what are the laws that we're enforcing? And then the other question is, should there be some sort of ex-ante regulatory regime? I think we could benefit at the FTC from considering what tools we have available to us right now for considering that kind of regulation. My colleague, Commissioner Chopra, has done a very good job highlighting the fact that we actually have rulemaking authority on the competition side that has been used precisely once in the FTC's history, and it had to do with men's and boys' tailored clothing, and it was more than 50 years ago. Maybe we try something else in that area, or maybe Congress gives us more directed rules about how we might regulate. But the benefit of ex-ante regulation is that when you set up clearer rules of the road, you can limit the need for the ex-post enforcement before problems get entrenched that are very difficult to remedy. Because the other thing that I think has been very clear from the conversations that have been going on internationally is identifying a problem isn't necessarily so hard. Figuring out what to do about it really is. And there are lots of good ideas, and I think I cite all the time my daughter who's in kindergarten has a teacher who says to the children, kindergartners can do hard things when they complain about the challenges of the work in front of them. And I think we too can do hard things, just like the kindergartners. And we should try to do hard things. But I think we should also acknowledge that they're challenging and that remedies can be imperfect, and we should not necessarily put all of the burden on enforcement remedies to solve all the problems we see in the market. And I wanted to make one other point in response to something that Isabelle said, which is that privacy issues really should be relegated to privacy regulators. We have a different structure in the US because the FTC does both privacy and competition enforcement. And for me, that's actually a real advantage because I think we see a lot of the same problems arising or related problems arising with the same companies in both privacy and competition. And I worry that if we don't think about those problems holistically, then we can have, for example, competition remedies that exacerbate privacy problems or privacy solutions that entrench competition problems. And so I actually think there's a real benefit, whether it's housed within the same regulator or involved in cross-regulatory communication, to thinking carefully and constructively about the ways in which competition and consumer protection issues are related and making sure that we're taking into account our government obligations to protect consumers in all of these areas.
Right, thanks, Rebecca. I want to bring in Diane and Fiona in the conversation. So going back to the two excellent studies you've been part of, I mean, obviously now the dialogue has started. We, as you see, the authorities are very interested in the ideas. We're discussing with parliaments how to implement them. I mean, if we go back to the studies and you think about the ongoing discussions, what do you think are, maybe starting with you, Diane, the core areas that you think we really should focus on in terms of trying to land those to start having some real impacts.
It's very interesting listening to the contributions so far, because it really brings home that there's an emerging consensus about the character of the problem and the kinds of areas where competition authorities need to take action. So this mix of ex-ante regulation, merger, control, enforcement, and so on. I think that's quite common. But as Rebecca just said, figuring out exactly what you do about it is the hard bit. And part of the challenge is that the business models are still evolving. And these are also very non-transparent companies. So they're experimenting on us all the time, and we don't really know what they're doing. So if you're concerned about something like the potential for algorithmic price discrimination, we don't really have the data yet to understand whether that's happening. It's worth saying that these companies have brought great benefits. Consumers love them. We're currently doing some research looking at the scale of the consumer welfare benefit in a static sense, from big digital companies. And it's the fact that they're large that means that they can bring so much benefit to consumers because of the network effects. But on the other hand, there are also large potential dynamic costs because the markets tip. So this is the trade-off that we're trying to assess. And it's one thing to say there needs to be greater scrutiny of all the mergers. In Furman, we recommended a digital markets unit, which would designate some companies with strategic market power. They would be required to notify all mergers so they get scrutinized. But when you're thinking about those mergers, actually the analysis has to be much more forward-looking, because it involves looking at what will happen to investment and innovation over subsequent years in a way that I think hasn't been comfortable or actually necessary very much for competition authorities. So that's one of the challenges. And you're in the world of then thinking about incentives and making predictions about behavior. You're not just looking at historical documentary evidence of behavior. So that, I think, is a bit of a challenge. The other really distinctive thing about the digital markets is the data. And in Furman, we focus quite a lot on data issues. And once you start thinking about it, you come to recognize that they're not kind of classic natural monopolies, that the network effects are in some sense created by a lack of interoperability. And we can email each other, whatever our email client and internet service provider, that's technically written out of social media, you can't do it. And so then when you start to think about what does not just data portability, but data interoperability really mean, you get into some really quite difficult technical issues. It's harder to do with something like social media. But despite GDPR and despite formal data portability, that's still not easy. The formats, the amount of information that you're given. So for example, if you download your data from Facebook, you don't learn which advertisers have been targeting you. It's still quite a constrained information set. Actually implementing that is a really big challenge, and so we're in the foothills of starting to think about that. But I firmly believe that interoperability of data and true mobility will be one of the keys to solving that dynamic puzzle where you make it possible for new entrants to come into the markets in the way that Google overtook Yahoo because it had a much better search engine. We've got to make that possible again so that these fantastic benefits that digital has brought to consumers can continue.
Yeah, I agree. Fiona.
Thank you, Andrea, and thank you for the invitation to be here. So the question, what from the report is the must-have? For the United States, I think the first must-have has to be a regulator, and that's because we don't have GDPR. We don't have any constraint on what platforms can do with people's data. So some law that deals with privacy, that deals with who owns data or who controls data, what it can be used for, the enforcement mechanism for making sure that there's compliance with that is critical. But I would echo what Rebecca said in that set of rules is inextricably linked into competition policy and enforcement, because the way in which those data are used to pay for services that we all enjoy or that are needed for an entrant to come in and compete for the services that we all enjoy, those really can't be separated. So I think it would be helpful to put a data regulator inside a competition authority, make those things linked so that we have consumer protection and competition working together and becoming complements rather than substitutes. I think it's quite important to think about a privacy rule that enables competition, that when competition intensifies, consumers get more privacy as a consequence because the environment is set up that competition gives consumers everything they want: price, quality, privacy, innovation. I also would second what Diane said, that the interoperability, again, linking both competition and privacy and data, is the way to lower entry barriers and to open up some of these markets that we think have been monopolized or otherwise made less competitive than they could be. And that interoperability and portability is probably the simplest and most reliable way to get some of the benefits for consumers. And then last, I would put into that that function, that regulatory function, as others have said, merger review. Just more thoughtful, careful merger review of transactions that are very small, that we don't understand. Slow that down so that authorities can be on the same level playing field as the parties, understand what's happening, understand the rationale for the transaction, whatever the efficiencies are, whatever the competitive effects are, and be able to do a better job at protecting consumers in that way.
And in terms of the processes, when you talk about regulation and rulemaking, I mean, are you thinking in many ways similarly to the way we regulate specific sectors where you have an investigation, come up with a set of rules, there are rights of appeal for a number of years, and then you review, monitor, and that
I mean,
kind of
I think what we're seeing is that digital markets move quickly, and our traditional methods are too slow. They're just not working. By the time you've worked out what the rationale for the transaction is, or the court has moved forward, the reason for doing the deal is long past. If it's exclusionary conduct, the victim is long dead. It's not really helping to preserve markets. So I think we do have to work on more speed.
Yeah, so you think we need to think about process as well, because in a sense we need to balance obviously the rights of defense with the fact that we need to be impactful when we do this.
Exactly.
And can I make a point there, Andrea, because in the US, different from our counterparts in Europe, we don't have the ability to order an outcome of an investigation unilaterally. We have to do it through an adversarial process. So either we can negotiate an outcome that we find satisfactory to resolve concerns, or we can take a defendant to court, either our administrative court or the federal courts. But in merger cases, parties have an incentive to comply with investigations and wrap up the case and move quickly through it. In conduct cases, they don't have that incentive. Their incentive is to drag out the process as long as possible and to engage in the adversarial process, because we can't wave the stick of we'll unilaterally order something tomorrow. And then the last point I wanted to make on mergers that I think is worth noting is there was a really important case that came out of the FTC and the CMA in late last year called Illumina PacBio, which wasn't technically a tech case. It was about a gene sequencing company. But the reason I wanted to highlight it is the FTC, working closely with our colleagues at CMA, challenged that merger. And we challenged it not only on the traditional Section 7 grounds that it was likely to substantially decrease competition, but also on the grounds that the merger constituted an act of monopoly maintenance by the incumbent company. It was a company that was a monopoly in gene sequencing acquiring a competitive threat. And I think it's important that we think carefully about mergers, not just in terms of the particular market shares and the effect of that specific merger, but what is the intent of the acquiring company, and how can that acquisition affect monopoly maintenance. And that's a tool that I'm really glad that we are using in these kinds of cases, and I think it sets a really important precedent.
Yeah, Andreas.
Yeah, just one word on this. The reports that we have seen, maybe except for the Stiegler report, are a bit focused on abuse control and not so much on mergers. Maybe this is for a good reason. I find in the digital arena, it's very hard to assess mergers, because we are supposed to know which kind of business model is the one that might be a competitive one in the future, whereas even the companies themselves have no idea maybe if they buy just 10 startups, which one of those is going to be the one that might be a competitor in the future. So merger control is very difficult in a certain sense in this area. On the other side, everyone asks for speed. I mean, in a way, merger control is much more speedy than abuse control. And I repeat myself, abuse control has always been called the Mount Everest of competition law. And now we're expected to climb the Mount Everest, the Hillary step, once a day, so to say, you know. So maybe we must concentrate a bit more on mergers and find out how to deal with these kind of mergers. And again, I want to quote you, who always said, especially the mergers that we have that passed by in the past, they make a lot of trouble today. And we get a lot of criticism for having let these mergers pass. So on the one side, merger control in this area is promising because with regard to speed. On the other side, it is very demanding and it asks a lot of prognosis powers from the agencies.
Yeah, I mean,
so
I certainly,
too.
You know, if I look at the complaints I receive, very often you can trace them back to a merger that basically shouldn't have been approved in that particular industry. Now, I wanted to focus a bit more on, move on and think a bit about sort of our collective anxieties. And one area I think I worry about, and I'm sure you do as well, is the kind of the blind spots, in the sense that, you know, all of us, we go to these events and spend a lot of time now talking about Google and Facebook and the Google cases, we're doing market study, others are doing that. But if you go to a conference of equity analysts today, it's all about the Internet of Things, about Alibaba, Tencent, voice assistant. So there is a concern that we're always a bit late to the party and they're kind of trying to fix things a bit too late. Now, I want to start with you, Diane, since you do a lot of research in the area of new technologies. I mean, what should we worry? I mean, are there lots of big things happening that somehow they're not really on our radar, and by the time we get to them, it might be too late and we'll be kind of a bit behind the curve, do you think?
So I was already talking about the importance of data, and I'd emphasize this again in the context of the Internet of Things, because the amount of data transfer and hoarding that will create is going to be absolutely immense. And you know, some areas get all the headlines. Autonomous vehicles are in the news all the time, but it's things like smart cities, the sensors and the communications network that are being built around cities, or transportation networks, and the kinds of deals that are already going on as companies try to corner certain markets and do that through sole ownership and access to all of the data. And so I would be looking really, really hard at the deals that are going on at the moment, particularly public authorities, actually, who are somewhat naive perhaps, or they're cash strapped and they need to get the money really quickly from what looks like a very attractive deal. You hand over some data, you get some cash now. Those terms ought to be transparent, but I think there should not be exclusive data deals to the extent possible to avoid those. Thinking really carefully about the way that in these markets it's using that data access, which gives you the information to create the loop that you talked about right at the beginning, Andrea, that data loop, that feedback loop, and it, you know, in effect creates the future monopoly positions that we would worry about 10 years into the future. So that would be my number one concern. Thank you.
I mean, Andreas, you think, again, I mean, should we do more advocacy, be a bit more proactive, as Diane was saying? I mean, in many ways, should we develop and become slightly more regulatory in our approach? You know, if I look at some of the regulators in the UK we deal with very frequently, like the Financial Conduct Authority or the Communications Regulator, they certainly spend more time doing horizon scanning in their sectors and trying to prevent problems. Obviously, all of us, we're dealing with the whole of the general economy, so we're in a very different situation. But do you think we should do a bit more of that?
I mean, we should try, but on the other hand, especially in this area, I find that particularly difficult. Rebecca has said, well, we know a little bit about the harm now that is done on digital markets. I find it very difficult sometimes to identify very, very subtle strategies of some companies to foreclose markets for their own sake and to keep competitors out. That is very subtle, and you only find these kind of strategies if you really talk to tech companies, to startups, to the nerds. We do that from time to time in Berlin because Berlin has a very vibrant and lively startup scene. And whenever I come back from there, I get a lot of ideas what one could do. So that is very subtle. And to do this kind of horizon screening, I think it is awfully necessary, given that these strategies are not obvious in many cases. And you should at least try to do that. I mean, this is one reason why the German Federal Cartel Office, together with the French Autorité, why we did this paper on algorithms and competition, because there haven't been many cases yet with this respect. We have seen one case, the Lufthansa case after the insolvency of Air Berlin in the past, where we really have taken a close look at algorithms with regard to prices. There haven't been many cases, but we did that in a certain sense in order to be prepared for the future, because I think we all know that there will be self-learning algorithms, and there will be algorithms that communicate and all these kind of issues. So we try to identify problems early on. But again, that is not an easy task. And don't ask me what kind of problems voice IT will bring, and 5G, autonomous driving, the Internet of Things. There's a lot to do probably out there.
But I think the reason that antitrust authorities aren't so good at this is because historically, if you think about it as a law enforcement regime, it's backward looking. Yeah. We wait for someone to violate the law, and then we go and enforce and say, you shouldn't have done that. By what I believe the consensus on this panel is that a little bit of ex-ante regulation is now needed because we have this more complex sector where we have to move quicker, and to protect consumers, that's necessary. Once you move to that slightly more regulatory framework, then this scanning the horizon becomes, of course, a best practice, because you're trying to develop some set of principles that you can say to the industry, here are the things that we want you to not be doing or to be doing, and we're going to enforce in that way. And that gives everybody a heads up before they get started on what the rules are. And so I think this is a different skill set. Yeah. It really is a new direction to go if you're an enforcement authority.
Isabelle, what do you think?
I think there's a different tool that we can use and that we have used quite effectively. It's the part where you do information gathering. And when you give information back to society, the market players, and this is something we have been doing a lot in France. I'm thinking of in 2010, we had done already a big study on online advertising at the time. And I think this is really something that we need, is to look at the economy before receiving any cases. And because we are regulator of the economy, so we need to know what's going on the economy. And I would like to give some example of that. So you have the type of bit theoretical study like we did on algorithm and like we did a few years ago on big data. That is useful because you can identify potential theoretical risk and also send some messages to the market. For example, one of the messages we wanted to send about algorithm is to the CEOs, you need to take care about what algorithm you are producing in your company, even those you are using, buying them from outside, even though they do not come from the company, you will be liable for any type of algorithm you have used. So that's a way to say, be aware, and we are sending you a message about the risk. Another thing is really to look at the new developing markets. And that's why we are currently doing a study on fintech, but also cloud services, blockchain, and the fact that the big platforms are arriving on the market for payment. So we do before receiving any actual case, because we think that those are areas of the economy that are changing, and we need to spend some resources, and we have few resources, but we really feel that this is something that we are obliged to do. Another thing that is quite striking is the fact that all the major competition agencies have created some form of new digital unit. It may be different in the CMA or the FTC or what we decided at the beginning of the year. But we need to have some people who are looking at new technological developments, also about using those new tools like web scraping or data science. And this is something that we need to discover a little bit like the companies that are discovering these new technologies. And we as public enforcers need to be able to use it also in our own way. So I really feel also that maybe something that hasn't been mentioned yet is the fact that agencies can give advice to the government about good regulation or the dangers of draft regulation, for example, that might limit innovation or competition. But also something I think we don't often put enough focus on is looking at the regulations that are in place and may have detrimental effects on competition. For example, that's what we tried to do last year about broadcasting regulation and saying to the French government and parliament, actually, today you have two different sets of regulation. You have very heavy burden of regulation on traditional TV broadcasters, and you have the platforms like Google, Facebook, or Netflix that are able to do a million of things without any type of constraint, for example, in terms of producing European content. So I think this is really something that we are quite well placed to do because we have a scope that is the whole economy. And we can also beware of not only thinking about new regulations, but making sure that the regulations that are in place are not creating an imbalance in terms of the level playing field. So I think that's something that maybe with what Rebecca was telling about a new role for the agency in terms of producing rule, maybe there is also this new role in terms of giving to the government and parliament some idea about things that might be changed in the current legislation also.
It may be worth adding that among the technical community, there's actually growing awareness of the need to demonstrate compliance. So they know now that they're going to need to demonstrate that their algorithms do comply with competition law.
Rebecca?
Yeah, I think that staying ahead of where the markets are, at least on top of and better ahead of, is our responsibility and our challenge. And I think I talked a little bit about using our 6B authority, which is one of the ways I think the FTC can do that really well. But the other point I would make is that it is important to me that we ask lots of the right questions and gather a lot of the right information. But it is also important that the people asking those questions and analyzing the information not just be lawyers and economists, but be people with real technological expertise, business expertise. If what we're trying to figure out is what decisions businesses are making, then thinking about it the way businesses think about the decisions that they're making strikes me as important. So I think the way CMA has set up its data unit is a really good example to set. I think we could absolutely beef up our capabilities in terms of having technologists, data scientists, but people with business backgrounds too, to think about how are the markets making decisions? Because I know as an attorney where I have some strengths and some analytical capability, and I also know where I don't have the best positioned mind to think about these things, and that there are people who are smarter and more informed, and we would benefit from their expertise. So making sure we have the capacity to do all of that is important. I would be remiss if I didn't point out that doing these things is resource intensive, and we have limited budgets, and our budget has been limited for a very long time. One of the statistics I like to share is that the FTC currently has the FTC had about 50% more employees at the beginning of the Reagan administration than it does today. And when you think about how our mandate has grown and how the economy has grown, even what technology existed then as compared to today, that's dramatically under-resourced. I mean, you can't think about it as anything other than dramatically under-resourcing. So I think our Congress has been paying attention to that. We got a small increase in our budget this year, which was enormously appreciated, but making sure that we can do the hard work up front of market analysis and market studies and understanding technologies in order to also facilitate our enforcement. All of that requires some investment, but I think it's investment that pays off to make all of the work that we do more effective.
And I mean, sort of building on this theme, I mean, in many ways, all of us on our side, we are enforcing the law, we are taking decisions every day, but at the same time, we're also sort of expert advisors to governments and Parliament. I mean, are we being too incremental in a way in our? I mean, if I think about the discussion we just had, in a way, we think we have budgets, we have day jobs, we have existing cases, so we're flexing things up or down in a very constrained way. And if you step back and you think about just the scale of change and transformation, isn't there a risk that we are kind of missing a bit the big picture? I mean, shouldn't, as part of our jobs, also think slightly more radical terms about budgets, about institutional design, and all of it?
Yes.
And I can see lots of
But I
but
think
again,
it's easier if you're not in the system.
Yeah,
I think this
exactly.
is
So
one of the
Fiona,
things that
exactly,
academics can do,
exactly.
is be outside the system and say, look, the system we have is frozen and the economy has grown and changed, and what we really need is a completely different way of doing things. So I see in the United States, similar to what Rebecca noticed, that courts are having an increasingly difficult time with these cases. They find the economics to be difficult, they can't bear the uncertainty. And if courts are going to find it to be too hard and are going to be getting the wrong answer as a result and seeking, asking for help, then maybe we just need to say, right, this is too hard for you, we need to find another way to do it and have a new law and a new system. And we don't have to always do things the way we did them yesterday. If the economy has changed enough, then maybe it's best to really rethink from a fresh, clean slate, not do incremental things.
Yeah.
Maybe one thing I wanted to add, because the point you're making, Andrea, is really important, is how do you adapt public enforcement in face of new challenges? And we know that it's often difficult for governments or parliaments to decide huge shifts in budget, responding to shifts in the economy. So I think that we really need to advocate, because it would be too bad if we decided to change the legal framework when in fact the only thing that the agency needed was more staff or more resources. So it would be not having a good answer to the real problem. So I think that the CMA is in a pretty good place compared to other agencies in terms of receiving additional funding, and I congratulate you for that. But not all the governments have this capacity to say, okay, you need to be reinforced. And I think a very good example of that is what we see with the GDPR. Will the agencies who are in charge of enforcing data protection be able to have the means to tackle those issues that are extremely complex? This will be a test. And I think that governments need really to be aware of that they might be missing an opportunity to answer those challenges only by not providing sufficient funding. And what was said of the FCC was a very good example.
Andreas,
I mean, of course, it's true to take a step back and look at it, everything from a slightly different perspective is a good way. On the other hand, it is my experience that also from inside an agency, based on practice, based on what you do every day. I mean, we have to take decisions every day. We know very well, to a certain extent, what works and what doesn't work. That is a good way forward too. And if I look at the landscape in Europe, for example, if I look at all the changes that we have seen in certain agencies, I mean, we have a unit for the digital economy. If you compare our IT forensic and data scientist unit to 5 years ago, it looks completely different. It is a cross-cutting issue. That's a special problem from my perspective, because everyone in the agency has to learn about these issues. And we, as heads, we have to make sure that we provide that possibility, that we bring together all these units, the digital unit, the forensic people, the data scientists, the case handlers. They must all cooperate. If I look at the kind of cases that we are doing, I mean, we really have been trying to bring together competition law on the one side, privacy on the other side in the Facebook case, just to mention it. But there are other cases like this. So I must say also from the inside, based on very practical experience, we have seen so many changes also with regard to priority setting. That is not a bad thing too. And this, of course, should put us in a place to give good advice to the government and also to the legislator, to Parliament, because they are the one who take the decision. So I think we need to be very agile in all these kind of issues. But again, if I look at Europe, I must say really a lot of things have happened.
Diane, it's your sense on, in a sense, you're outside our system. Do you think we're being too incremental? We should be bolder.
So I want to answer both yes and no to that question. And I think yes, given the speed with which the markets are changing and the how rapid the effects of the technology can be. The trouble is that I think there are still things that we don't quite know the answers to. So yes, we need to change radically in our approach, but what to is the question. And there are still some unanswered issues there. How do you do this kind of analysis in markets with these highly nonlinear dynamics that can tip really quickly? And I think we economists haven't answered that yet. How do you think about market definition when you've got a complex tech ecosystem? What's the right level of the technology stack at which to impose regulated standards in some sense, because you're going to reduce competition there in favour of enhancing it elsewhere? So these are very detailed questions, and it's quite hard to say, yes, we've got to do some radical changes until we've made some more headway in answering these questions, I think.
But in terms of, I mean, this is probably more for Andreas and Isabelle and Rebecca. So there are all these new things, you know, we're talking about machine learning, AI. I mean, is there a role for also us to talk to governments and argue for centers of excellence somewhere in government on some of these areas? Because, you know, I mean, it doesn't really make sense for the CMA to become a center of excellence for machine learning. Machine learning cuts across pretty much everything government does. Isn't there a role for us essentially to convince other parts of government that there needs to be greater investment on the public sector side on some of these skills, with our agencies being then beneficiaries of that to some extent? I mean, is that a discussion that is happening like in France or Germany?
So we have a good example of that because there was a rather thorough exercise that the French government started a few months ago, and involving the different ministries with an interest in competition, in digital, excuse me, and also the different regulatory agencies. And one of the outcomes has been to create a new type of platform within government that will be dedicated to providing services in terms of artificial intelligence, algorithm, etc., for the different agencies. And I think that is quite an interesting way of doing things, to act as a platform, not to have each and everyone the same expertise that we would have difficulty in funding and also in recruiting people. So it will be a test. It raises some legal issues because how do you use those external resources for your cases, for example? So we need to find some solutions, and a law that is currently discussed in Parliament will try to answer some of those issues. How do you decide how this new unit will define priorities? So we'll have a sort of board with deciding the new type of investigation. But I really think we need to go in that direction. And another type of way of working together that I found really useful was something that we created between the regulatory agencies. It's a network that is really effective. And one of the first productions that we did together was a study about those voice assistant and new type of Internet of Things new developments. And we did together with the Data Protection Agency, the Telecommunication Regulator, the Broadcasting Regulator, ourselves. And it was the first time we had done something like that, where we hear the different voices in the study, so each agency gives its perspective. I think this is really something that we need to try, because we cannot stay within our own world and see things only from our perspective. We really need to have a sort of more global view all across the different regulators and the government, of course.
Andreas?
I mean, it's not only a cross-cutting issue for competition agencies, it is always a cross-cutting issue for governments. This is why, for example, in Germany, we have an ongoing debate since years if we would not need one digital ministry in order to bundle and focus certain strengths with regard to the digital economy, which did not happen so far. But there are a couple of initiatives by the government in this direction. For example, we are working heavily on a data strategy in Germany that is driven by the Chancellor cabinet in order to be able to deal with these kind of things. And I think this is really an excellent idea. There's no debate if we need kind of a think tank with regard to digital developments and all these issues. We don't have that yet. What we do have is a bilateral exchange among us, among other regulators, a financial regulator, for example, because we also look into certain financial issues. So for the time being, we do it this way. And if you have agencies that are well equipped with regard to these questions, if you find the human resources mainly who can answer these kind of questions, I think this is also a good way to deal with it. So I would say, different from France, this, as far as my agency is concerned, this is not institutionalized. But on a bilateral basis, there's happening a lot of exchange on strategies, what is happening in certain markets, because a financial regulator knows very well what is going on in this area, and this is why, just as an example, why there is this bilateral exchange. So I think there are many ways to make sure that we gain the knowledge and that we have the resources in order to deal with these questions.
It seems to me the key issue is having the human resources on the regulatory side, having those skills, because they're in short supply. The private sector can pay much more money. And that, more than what's the scope of it, seems to me to be the key question.
Yeah. And Rebecca, what's happening on the US side in terms of?
So I think we have a couple of mechanisms for interagency communication and coordination that are some that are formal, right? The FTC routinely comments on other agencies' proposals and provides a competition or a privacy perspective on things other agencies are doing, and we take comments from other agencies on the things that we're doing in a formal written way. We also have informal communication and collaboration, and I think all of those things are very important. There's a history in the US of setting up special commissions or task forces to study particular issues and make recommendations. And I don't have any objection to that in terms of some of the issues that we're dealing with here, but I would put it on all the things that we've discussed that would need a legislative change to accomplish. It would not be my top priority. And in fact, I would worry about investing resources in a fact-finding mission or an expert commission that would functionally operate to delay effectuating the kinds of changes that I think we have the capacity and the knowledge to begin effectuating right now.
I think in the US, sectoral regulators are traditionally not very concerned with competition, or at least the perspective from the competition agency is that they're not. So working with them would tend not to help a competition agency do better at enforcing competition, but it would be more, getting actually some engineering expertise or something like that from the sectoral regulator. And I think, as Rebecca's pointed to, that might not it might not be the solution to the problems that we have right now, it might not speed up good policy.
Yeah, I mean, I guess the reason why I kind of focused on this question was more, seems to be a consensus that we were thinking some regulatory solution is important. But I spent 5 years as a regulator in the sort of comms authority here, and you start thinking about interoperability, data portability, it's complicated, it's resource intensive, and you have a colossal amount of resource and expertise on the other side. So somewhere on the government side, you need that expertise. One answer is you build it into your agency, which must be part of the solution. But obviously, if you are able to tap into some of this expertise on somewhere else, on the public sector side, that should help on that. I want to move a bit more on the sort of to the international side of things, maybe starting with you, Andreas, given your role in ICN. And again, if we fast forward a few years and you think about institutional design and you think about actually achieving good impact, again, we're very incremental. There is a lot of international cooperation. We see it today, but it happens a lot. But in practice, you need to convert that into decisions, outcomes, remedies. I mean, do you think we should focus on changing something? Are we broadly in the right place? Are we evolving towards the right place?
I think big tech is a chance also for international or bilateral cooperation. That is a cooperation that is different a bit from the past, from my perspective. If I think, for example, of the ICN, where we had a couple of discussions how to deal with these issues, and I remember some head of agency workshops that we had alongside these conferences, where we as heads really said, well, we need to do much more about it, and we need to do it. We need to do more also within the framework of this particular forum. And if you look, for example, at ICN conferences today, if I think of Los Angeles in May, it is hard to find a topic that is not linked to the digital economy. So in a way that has really given a certain boost to how we deal with these issues and how we exchange. And I'm very happy to see this, that the ICN has really grown into that role to be of a particular importance for that. By the way, of course, it's not only the ICN. We have great discussions on these issues, very much in-depth debates at the OECD at the same time. An excellent debate that is happening there too. And also on a smaller scale, for example, if you look at Europe, if you look at the European Competition Network, the ECN, here we face some problems on the one side, because if you look at the ECN and if you look at case allocation within the ECN, you could, of course, say that the European Commission is always the best placed authority to deal with these cases, given that these strategies, these companies, they are never regional, local, or national, not even European. They're global, usually, On the other hand, we know the Commission cannot do everything. We know we have very skillful and capable agencies within the ECN who can also deal with these kind of cases. And having said that, of course, we have an extremely intense exchange on these kind of cases on the whole digital economy with the European Commission, but also among ourselves. So that is a great chance too. And last but not least, I would like to mention bilateral cooperation. And also from my perspective, that has been growing into a new format in a certain way. I mean, we have done 2 studies alone with the French competition agency on big data and competition, on algorithms and competition. We have mutual visits from the Federal Cartel Office here in London with the CMA. We have just recently seen colleagues from the CMA in Bonn in order to discuss. And these are very fruitful debates that we have here. So also on a bilateral basis, there's, at least from my perspective, there's much more going on than in recent years. Because we all know these cases are global, the problems are global, and a problem that poses in Germany, I can be pretty sure I can call you and you will say, yeah, I've heard about it, it's the same problem here. Or I could call Isabelle and she would give me the same answer. I could even call Rebecca in Washington and she would say, well, it's not so different over here in the US. So that is really a chance also to expand on it. And that is happening in practice. What remains to be seen in 5 years, if we can manage to transform that in a certain kind of different institutional cooperation, if we can formalize that better in a certain sense, it will be very important to see how we integrate the UK into these kind of deliberations, since you are no longer part of the ECN. And well, we cannot exchange our views as freely in certain matters, at least, as we could before. So that will be the key question. But I think we see the path, but we do not see quite yet where it leads us from an institutional point of view. Isabelle, Rebecca?
Yeah, I second everything that Andrea said, and I would add that really this cooperation has become for us one of the key assets that we can get, because those companies tend to have the same type of conduct all over the world. So they like to function globally because they can benefit from the network effect. So that's one element. And second, what we get from those discussions is really information about what the companies are doing, and also the way the different enforcers are trying to look at those type of conduct. And of course, there are different levels of cooperation within the ECN. You might say it's the most integrated type of cooperation because you need to notify new cases and give very detailed information about how the case is being built. And one thing we can say is in the past 3 years I've spent at the French agency, I've seen really ECN moving forward very quickly in terms of changing the way we function, for example, with the early warning system, the digital working group, and also the fact that we now realize that we need to have very quick information about a case that is even being considered, not being open, but being considered, because we need to know that, oh, this agency is going to take this case, so maybe I leave the lead to this agency, and how are you going to look at this case? And also the way we build on the other cases, for example, online advertising case, we had several cases by the European Commission, and when we did our own case at the end of last year, we were able to rely on what the Commission had been defining as a dominant position. So this is really extremely helpful. And maybe another topic I would like to add is the way we can discuss as a head of agency, so without public, and we can go in much detail about, for example, how to set up a good data unit, and we had some very detailed conversation in different instances. And the way we can analyze, for example, self-preferencing or algorithm. And maybe I would like to add that I also rely on those conversations to achieve convergence on substance. And I would like to say how important for us has been the work that we did within the G7 in reaching a common understanding on digital and competition. At a time where everybody was talking about the transatlantic divide and the fact that the Americans were not seeing things the same way as the Europeans, not doing the same. Well, in reality, it has been a challenge, but we really managed to put into writing the way we saw those problems, and with the Americans, Canada, Japan. And for me, it has really been a success of cooperation to say that we were able to put into writing how we were defining those challenges and the way ahead. So I'm really hopeful in terms of having all type of different cooperation. They do not compete with one another. They are each and every them is really useful. For example, I come back from Australia, and the talks I had with the ACCC were incredibly useful. So I think we need to keep time on our schedule to keep on doing those discussions, and it gives us strength in terms of addressing those big companies, big cases, big challenges.
Rebecca,
yeah, so I'd add, I think that to the extent that we can converge and work together, it's an excellent thing to do. The model that we have in the United States is the dual level federal and state enforcement. And we know that when we bring cases with our partners in the states, we are more effective and more likely to succeed than when we try to go on our own or when they try to go on their own. So being able to do that is enormously valuable. Being mindful of the fact that probably there is more structural and statutory difference between the US and Europeans than there is within Europe or even between Europe and the UK. So not just in terms of what laws we're enforcing, but also the mechanism for the enforcement. So it's not as easy as filing a case, you know, federal and state AG joint together in court in the US. You can't do the same sort of international collaboration. But to the extent that international competition authorities are seeing the same issues as violating each of their respective laws and can converge on a solution, I would imagine that is enormously helpful in developing effectiveness and leverage with the companies that we're investigating and the problems that we're trying to address.
Thanks.
Yeah. I think that the international cooperation is actually a really great thing for economists, because the economics of these platforms and the harms is jurisdiction free, right? If you can figure out the right answer and you can do solid economic analysis, it's as useful in any country as in any other. So I think the economists have a lot to contribute, and we are working, we haven't done enough, but more tools to show liability, more ability to measure some of these quality and data harms, more development of remedies that are preserving of the benefits and minimizing the harms so that regulators have some sense of where they could go. That would be good. But I think the international cooperation is really great for the economists, and the economists should be seeing that and trying to help as much as they can.
I agree. So a question from a member of the audience asking, saying speed of process depends on evidence. Why routinely use documents and economic evidence rather than use witness and expert witness testimony? Now, that obviously depends on the process. I guess you are extensively using it. So if we think about mergers, for instance, you do depositions in a way that we don't, but we're thinking about.
Yes.
Do you find them useful? And
So in any case that we're considering, we tend to have 3 buckets of evidence: documents, testimony, and economics. The reason we rely on documents is because they tend to be the most reliable in terms of understanding what is actually going on. And that's our job. Our job is to figure out what is actually happening within these companies, what are the likely effects of a merger or a particular type of conduct, how are the companies seeing it, and contemporaneous, ordinary course of business documents are going to give us the most honest representation of what's actually happening, rather than witness testimony taken today when an investigation is undergoing that could be more self-serving or could be altered or could be sort of tailored to give the answers that we want. So to the extent that we're looking to get the right answer, I think we want the most reliable evidence, and that often comes from the documents.
I think lawyers don't understand how difficult antitrust cases are often, because if it's a classic tort, you know, somebody hit somebody else, they both go into court and they say, here's what happened to me. But when you're engaging in an antitrust investigation or a trial, there isn't a witness for the consumer. The consumers are the millions of them, and they're all harmed a little bit. And they don't have an executive to get up on the stand and say, here's what happened. And so if you rely on witnesses, you end up with a witness who stands up and says, I promise to keep competing after my merger. And as we've seen recently. And this, of course, is not scientific. That executive has a fiduciary duty to his shareholders, and if there's a way to make money that's legal, then he's either going to do it or the board is going to replace him with somebody else. And the economics can tell you that, and the witness may be very good-hearted and say, I plan to keep on competing, but that's not really helpful to a decision maker.
So I'm less sanguine about the reliability of documents, because they can be strategic too, and they do give you that backward-looking perspective. So to get the forward-looking bit, you need the economics.
Sure.
And then, of course, there are hearings for witness evidence, and you put the weight on it that you think it deserves.
Right, and we give a lot more credit to contemporaneous, ordinary course documents than we do to documents developed in the course of an investigation or in preparation for litigation. But the other point I'll make about speed is I don't think we should assume that taking witness testimony is necessarily a path to speedy resolution. It's an enormously time-consuming process to set up an investigational hearing and prepare and exchange interrogatories. And so I wish it was as easy as, and maybe used to imagine that it was as easy as calling someone on the phone and saying, come in tomorrow and we'll have this conversation. But it doesn't necessarily speed things up as much as one might hope.
Andreas, I know you have experience of witnesses in your cartel cases, which also is...
I mean, we make use of it all, I would say, because if you go to court, and that will be the same in all of our countries, as we say in Germany, every stone is turned around, and the court looks at what is under that stone. So it depends on the case, I would say. We need to hear witnesses in this. The court is very demanding with regard to that, especially in cartel cases. Of course, we look at documents that we seize. And of course, we need a sound economic assessment of a case. So in a sense, I would not even weigh that in a certain sense. I would say it depends on the case, and it depends on the evidence that each of these instruments provides, and to which extent you make use of it in a certain case.
That's right, and there can be cases where there just really aren't very good documents, but there are really good witnesses, maybe not for consumers, but to help for customers of merging parties to think about competitive effects. So I think Andreas is right, that it's very case specific, and we have to investigate all the evidence.
Okay, I just want to finish on a sort of final reflection for all of us. Again, going back to this idea of where we'll be in a few years' time. I mean, in a sense, if we are in a few years' time looking back to where we are today, and kind of assessing how we are dealing with the challenge, where would you, I mean, in a sense, we can do advocacy to other parts of government. We can try to convince Parliament to change legislation. We can do more cases. We can be tougher on mergers. What are, you think, the areas where there is a greater risk that when you look back, you think, well, I probably missed, I just didn't quite put enough resources, enough time in that particular area, if you think about the overall digital challenge?
You want to know where I made my mistakes?
Where you're going to make
in a few years' time, where you think today, you might be making mistakes today.
I mean, it's always a way of try and error, of course. And looking back, you always find things where you think, I could have been faster. I should have put more resources into that. But I mean, afterwards, you always know better. I think what is at stake now, and that is important again if we try to make a forecast for the next 5 years. The key question, I mean, I see my task. I mentioned that in the beginning. That is, keep markets open and contestable, and protect the consumer from an abuse or misuse of market power. And in 5 years' time from now, people will only ask me, did you get there? Have you been relevant? Does your agency make a difference? That will be the key question, no matter how I get there. No matter if I do that via merger control and be more strict here, no matter if I do that via abuse cases, no matter if I do that on the cartel side, the question will be, does your agency make a difference? It's not about brilliant decision. It's not being about at the forefront intellectually. I mean, that is always nice to have, and that is important, and that gives a lot of satisfaction. That is not the point. But we need to be relevant, because that is expected by the stakeholders, that is expected by consumers, and that is expected by policymakers. And if we don't do that, they will react. And that is, for me, that is key. So be efficient, be effective, speak up. If it's advocacy, it's advocacy. Then I will speak up. And if it's resources in a certain area, I will do that. I would try to react, and not only react, also act beforehand.
Isabelle?
I think one of the tests of our success as enforcers is will there be the perception that no company is above the law, that a digital company, like a company in another sector, can be subject to procedure and has no special status or special way to avoid the common rule of competition? I think another test is, are the markets perceived to be susceptible to competition? Can we imagine a competitor becoming the new search engine or the new social network? So that's, for me, something that is quite important. The level of concentration in certain markets, that can be a test of how markets are really functioning. Also to look at the profits that are being acquired in the different companies. And one of the things that was said this morning that was really interesting is to also get the perspective from the venture capitalists and the people investing in those companies. I think that may be one of the areas we need to look at more. So I think these are one of the few things that we may be able to look at to know if we have done our job as we should.
Rebecca?
I think the mistake that I'm most worried about making is not learning from mistakes we have made before. So I think, for example, Andrea, you talked about how you see questions and complaints all the time about mergers that probably shouldn't have been approved. If we don't take the time to figure out why we got it wrong the first time, not only so that we could potentially correct those specific problems if we need to, but also so we avoid making the same mistakes again, that's the mistake that I'm concerned about. Markets are changing. We're going to do our best, and we need to do our best to keep up and catch up and get ahead of them. But where I really worry is that we don't learn from the lessons that we've already encountered in terms of how to improve our analysis, how to make better predictions, how to understand markets better, and stay ahead of the problems that we haven't always been ahead of before.
Fiona, Diane, sort of from the outside looking in, do you think we are learning enough over time, or should do more?
I guess the one question I would ask is that competition authorities are going to have to get more comfortable about shaping markets, because these are markets that tip. So whatever
That's
choices
an important
you make,
point, I think, yeah.
it's going to be a different kind of role than in the past. And so I think my big worry would be that the authorities don't step up to that challenge.
We're too timid on that point, yeah. Fiona?
I think we need to create the environment where when people look at markets, they feel like they're dynamic, that they can enter, that there's the possibility to enter, that there is creative destruction. Sometimes an incumbent actually loses because they don't have market power, because there are good conditions for entry, and somebody enters and defeats the incumbent. And that sense of dynamism and of equal opportunity and competition on the merits, I think, is super important. And if we make a mistake and the market tips and we end up with an incumbent that didn't get there on the merits, then I think we're in this world of regulation and interoperability and so on to try to fix that and make the ex post the entry possible.
Can I make one follow-up point to what Diane said, which I think was a really good point, that we have to be comfortable with the idea of shaping markets. But I think part of that is being comfortable with the fact that by not acting, we are also shaping markets.
Absolutely.
And so I think there's a sense that taking action is the way competition authorities drive markets, but not acting also is driving markets in particular directions. So understanding that whether we are choosing to do something or not to do something, we are shaping markets, and being more comfortable with the idea that that's an inevitable course, and we should think seriously about what the outcome
I think it's baked into our legal process very often, that courts think that not acting is somehow an appropriate default.
Right.
And of course, that's not supported by any kind of economic analysis. That's not an appropriate default. It's just an accident.
Maybe just one sentence, Andrea. I do not want to heighten that inappropriately, but I think your question goes a bit also beyond competition, because we have just seen a poll in Germany where 50% of the population have said that they don't believe that market economy is the best system anymore. So we have to wonder, why is this so? I'm not an expert on that, but I could imagine that some of them said so because they see these super powerful companies, and they see maybe that there is not enough happening. So there is also a question to protect the market economy as the system that we have. It's crucial in a way.
Excellent. So we need to wrap up. So I'd like to thank all those who have sent in questions via Slido. Apologies to those whose questions we couldn't pick up. So we'll be back in around 30 seconds with a very final quick wrap-up by my colleague, Andrea Gomez da Silva. Thank you very much, and thanks to all of you on the panel.